Welcome to the Explainer. Today, we're taking what looks like a dry, boring legal document and turning it into an absolute true crime-style financial thriller, straight out of an Arizona administrative hearing. We're going to examine a wild case where thousands of dollars of community money were just quietly siphoned off into an exclusive group. And we'll see exactly how one determined homeowner brought the whole system crashing down.
Okay, let's just jump right into this. Here's the actual smoking gun. This is the exact petition complaint filed by a unit owner named Cindy Denapoli against her very own condominium association, Southern Ridge. She essentially raised her hand and pointed out a massive red flag. She said, hey, management fees of up to $9,667 a month are being assessed to all of us owners as part of our standard HOA dues. But that money is directly benefiting only a separate, private rental pool operating inside the community.
Section 1. A condo with no residents.
So, to really understand how this strange legal battle unfolded, we first need to set the scene, because the dynamic at this specific community is completely bizarre. Southern Ridge wasn't your normal, everyday neighborhood. Honestly, it was basically a ghost town of investors. See, after the real estate market collapsed around 2009, the original owner, Right Place Properties, completely dropped out of the picture. Title to the units was assumed entirely by a patchwork of about 50 different investors. In fact, Cindy herself only received the deed to her unit in lieu of foreclosure. Because of all this fallout, Southern Ridge had literally zero owner-occupants actually living on site. It was 100% investor-owned.
All right, moving to Section 2, the rental pool scheme.
Because of this weird investor-only dynamic, a highly controversial in-crowd popped up to take control of the property. And honestly, this setup brilliantly illustrates the whole David versus Goliath power dynamic that completely took over Southern Ridge. A majority of the unit owners banded together to form what they called a rental pool. Out of 113 total condominium units, 102 joined this exclusive club. That left just 11 outsiders, including our petitioner, Cindy, completely excluded. They were just left out in the cold to fend for themselves, while this massive in-crowd controlled the board.
And that brings us to the magic number. The heart of this entire mystery comes down to this exact, strangely specific figure: $9,666. This was the monthly management fee that Cindy noticed was being billed to the entire community. And remember, she wasn't just paying for management. There was also an additional $800 a month going out just for swimming pool maintenance. I mean, the numbers simply did not add up for the level of service the association was actually getting.
Section 3. Following the money.
So the absolutely crucial question is, where on earth was that massive check going every single month? Because it sure wasn't just paying for someone to mow the lawns. Check out this 4-step setup. It's actually fascinating. Step 1. Preferred Communities, which is the accounting firm for the HOA, writes that $9,666 check directly to the rental pool, not to a management company. Step 2. The rental pool then takes that community money and pays PEM, the actual property management company. Step 3. The rental pool uses whatever cash is left over to pay its own private expenses. We're talking things like tenant screening, interior repairs on their specific units, and legal fees for evictions. And Step 4, the real kicker: any remaining cash is declared a profit and distributed strictly to the 102 insiders in the rental pool. By design, it bypassed Cindy and the other outsiders entirely.
Now, you'd probably think an operation handling nearly $10 grand a month of community funds would be super official and highly regulated, right? Well, wrong. According to the testimony, this rental pool wasn't even a legally registered business entity. It was literally just an informal group. No corporation status, no LLC, and not even a tax ID. Just a casual group cashing massive checks.
Which leads us right into Section 4, the legal showdown. So Cindy finally says enough is enough and takes the Southern Ridge Board to an administrative hearing. And it turns into this dramatic clash of perspectives. Cindy's testimony was just plain, simple logic. Normal, going rate HOA management fees are around $10 a unit per month. So a fee of nearly 10 grand is drastically inflated and is obviously just a vehicle to subsidize the rental pool's private expenses. On the flip side, HOA board member and rental pool finance guy William Watkins mounted this highly technical defense. He totally blamed the property managers, claiming they explicitly asked to be paid indirectly through the rental pool rather than directly from the HOA. But Watkins did admit under oath that what they were doing was, in his own words, somewhat controversial, and that their own accountants were actually concerned about the legality of it.
But here's where Watkins' defense just totally crumbles.
During the hearing, a massive conflict of interest was revealed. The 4 individuals sitting on the HOA board, the ones with the fiduciary duty to all 113 units, the ones authorizing these checks, were the exact same 4 people operating the rental pool committee. They literally just deferred the rental pool business until the end of the HOA board meetings. You literally cannot make this stuff up. The people writing the checks were the exact same people cashing them.
Section 5. The final verdict.
So how did the administrative law judge untangle this absolute mess of an accounting scheme? With one specific legal hammer. The judge looked at Arizona Revised Statute 33-1255C2, which states, any common expense or portion of a common expense benefiting fewer than all of the units shall be assessed exclusively against the units benefited.
What does that actually mean in plain English? Basically, the common expense rule means that HOA expenses that only benefit a select group of owners simply cannot be billed to everyone. You absolutely cannot use the collective money of all 113 units in Southern Ridge to subsidize the private eviction fees, the rental collection costs, and the interior repair bills that belonged exclusively to the 102 units in the rental pool. It's just not allowed. And boom, there's your verdict. Applying a preponderance of the evidence standard, the judge definitively concluded that Southern Ridge was violating state law by filtering shared community funds through this exclusive backdoor channel. The setup was undeniably illegally shifting the financial burden of the in-crowd right onto the shoulders of the outsiders.
As we wrap up the legal timeline here, which was officially certified as final in June of 2014, Cindy pulled off a massive win for the outsiders. The administrative orders were super strict. First, Cindy was officially declared the prevailing party. Second, the judge ordered mandatory future compliance, legally forcing the HOA to stop their funneling scheme immediately. Third, the association had to return Cindy's $550 filing fee. And finally, the HOA was hit with a $200 civil penalty payable to the state. It was a complete top-to-bottom dismantling of the rental pool's accounting trick. So, after unpacking all of this, the secret clubs, the nearly 10 grand checks, the epic legal takedown by a single homeowner who fought back and won, it leaves us all with one very real, provocative question. Do you actually know where your monthly HOA fees are really going?